Morning. This is a matter of Leach versus Gates, case number 2602501DM. Present in the virtual courtroom, we have both parties along with their respective attorneys. We are here on the plaintiff's motion for a temporary order. I have read the motion and the response. Ms. Curry.
Thank you. Judge, this is the plaintiff's motion for a temporary order. The parties have 3 children, ages 7.5, 3, and 8 months. This is a divorce case in which you already issued a 1-year PPO in a companion file in December of 2025. As set forth in my client's motion, on a temporary basis, she's requesting joint legal custody, that she have primary physical custody, and the court establish a parenting time schedule for the defendant. I think we definitely need a referral to the friend of the court and a requirement that the parties use a communication app when and if his bond conditions allow any communication with my client. I would indicate when we filed the motion, as the court is aware, defendant was already on probation on a deferred sentence for a DV conviction where my client is the victim. Since filing the motion, unfortunately, he was rearrested in a horrific incident where he physically assaulted my client again, took her keys and threw them into the street, physically got into her car, took a Starbucks unopened coffee bottle and smashed it into her boyfriend's face, grabbed the youngest child's car seat out of the car so that it fell to the ground. 8-month-old sustained, luckily, only very minor injuries to his foot and some cuts. CPS is investigating, has already talked.
A virtual family court hearing opened as attorneys presented arguments regarding temporary custody arrangements, following serious allegations of domestic violence and child endangerment.
To my client, and the older child has photographed the youngest child's injuries, and at this point has only told my client that they are waiting to speak with Mr. Gates. I have the name of the CPS worker. This most recent incident is on top of sort of nonstop phone and text threats that my client has received from Mr. Gates. He's on a $10,000 bond, and there's a no contact order right now. Mr. Carpenter is Mr. Gates's criminal defense attorney as well as his representative in this divorce case. I obviously disagree strongly with his factual recitation in his response and would only say I think that reads more like a made-for-TV jury closing speech than anything else, where you blame the victim for everything, take no responsibility, want the court, even after his client pled guilty in the first case, wants this court to think that the Walker police, the prosecuting attorney, Judge Christensen, and the 59th District Court are somehow incompetent and don't know what they're doing here. Would also indicate that the police talked to the 7.5-year-old regarding what she had witnessed here before any adult, including my client, had spoken with her at all. And it's my understanding that she confirmed exactly what my client had said had happened here and what she saw her father do. So I think at this point the court is looking at a dad who I'm sure loves his kids but has some serious anger management challenges. And unfortunately, as a result, there are clearly threats to my client, but also to the children.
The plaintiff described ongoing threats, recent criminal accusations, and concerns of children's safety, requesting custody evaluations, structured communication, and limited parenting exchanges.
So we would ask at this point, as I said earlier, that this matter be referred to the friend of the court for a full evaluation and recommendation as to custody, parenting time, and child support, that you order that the parties use our family wizard for their communication once his bond conditions allow it, and that till then any communication would have to go through presumably his mother, who's been the third party, who's been willing to help And my client, to her credit, has worked with the mother and even allowed some overnight contact for Mr. Gates with the children since this incident occurred. I think the parenting time schedule my client would suggest at this point, which I think is generous, would be alternating weekends and maybe a midweek evening, assuming CPS doesn't have a problem with that. We would also ask until the friend of the court looks at child support, that the court simply order that child care costs, which will be expensive in the summer for 3 children, just be split by the parties for right now, and that once an appropriate child support amount is determined, it can be retroactive to June 1 with credits for the child care. And that's my client's position right now.
Oh, thank you. As I already indicated, I have read the motion and the response, and we're not gonna litigate the criminal case right here. So I just want to make that comment before I ask Mr. Carpenter to respond.
No problem, Your Honor. I appreciate the fact that you've read everything. I would just like to point out that since the parties separated, they've been exercising parenting time on a 2255 schedule. We've been able to facilitate the parenting time exchanges without my client violating the no contact order. We've, even since the latest incident, the parties have continued to do the 2255 schedule. My client just had the kids for his 2 midweek overnights. We would ask that the 2255 be.
Defense counsel disputed the allegations, arguing existing parenting arrangements remain effective and claiming evidence would challenge the plaintiff's version of recent events.
The schedule be adopted as the order of the court. That's what they're doing. It's what they're still doing. It's what the kids know. There's clearly an established custodial environment. My client is in the marital home with the children, with their toys, their beds. Ms. Curry is, as always, a very effective advocate, but this, the criminal case did not go down even remotely how she was told. There is an audio tape that was recorded by Ms. Leach that was provided to police. I have it in my possession. Your Honor, if this case doesn't settle, you're going to hear it. You're going to hear who the aggressors were. You're going to hear Ms. Leach telling my client at the beginning, my client objected to this violent convicted felon, Mr. Bowman, being around the children. And Ms. Leach was threatening him. You're about to get your ass beat. You're about to get your ass beat. Just before her violent felon boyfriend got out of the car and did exactly that to my client. That's what happened. That's what's on the tape. Ms. Leach claims to have an injury. One thing that wasn't talked about is my client wasn't arrested for the fight with the boyfriend. He was arrested because she told police that my client hit her. That's not on the audio tape. That didn't happen. She showed an injury, which is clearly an old injury that is in the process of healing. We'll deal with this with the criminal matter, at the criminal trial. I'd also like to point out, Your Honor, my client's probation officer isn't violating them because this is a very, very weak case. And I realize the police show up, there's a lot of, there's yelling, everybody's upset. It's very easy to arrest my client just to separate the parties. But this is a very, very problematic prosecution, and we will deal with that in the criminal court. But in the meantime, I would simply ask that the status quo be maintained, and I think that my proposed order addresses everything. I would also like to point out, I don't know that Ms. Leach was fired from her job and Mr. Bowman doesn't have a job.
The defense maintained criminal accusations were weak and politically influenced, while the plaintiff insisted law enforcement acted appropriately based upon evidence.
I don't know that there are going to be summer daycare expenses, but I would agree that to the extent that there are, it should be shared between parties.
All right, thank you. Ms. Curry.
I would just indicate that my client has her own apartment. She had originally lived with her parents when she had to separate because of the domestic violence from Mr. Gates. She's been more than reasonable here because he worked in the mobile home park where they lived. She allowed him to stay there. She now has her own apartment. I think trying to say that she, again, made up any of this is ludicrous and assumes that the police don't know how to do their job. I don't think Walker is known as a hotbed of coddling domestic violence survivors, and charges were brought here a second time against him.
All right, thank you. I guess my only question is, do you dispute Mr. Carpenter's statement that they have been exercising the 2255?
They were doing that. He insisted on it. She did it. It stopped, obviously, when this incident occurred. And she doesn't think now, given everything that's gone on and what the children witnessed, that many back and forths every week is a good idea. Nor does she know how stable Mr. Gates is right now.
All right.
So that's why I think her suggestion for alternate weekend and a midweek, so they didn't have to go too long without seeing them, would be best for the children right now. And obviously we can revisit this down the road.
Your Honor, if I can interject, they're still doing the 2255. My client had the children just the past 2 days.
There was only 2 days this past week that was withheld from me. The last week, Wednesday and Thursday.
Okay, so you're still doing the 2255.
Ms. Curry?
They are not doing the 225.
Discussion shifted toward parenting schedules, with disagreement over whether prior custody exchanges continued after the arrest and amid escalating tensions.
5 right now. I mean, she's allowed overnights. She allowed an overnight last weekend through his mother. She allowed another overnight last night. She's tried to allow the children to maintain some contact with him, but they have not been doing a 2255 since his arrest.
I'm sorry, that's simply false.
Okay, all right, we're not going back and forth is not going to solve this here. Obviously, we need an investigation. And I think I haven't heard anybody say that we don't. So on a temporary basis, the court will award joint legal and joint physical custody of these children to both parties. It sounds like that there is an established custodial environment with both parties. However, due to the pending criminal charges, I think at this point, I think the 2255 is too many transfers back and forth. So I will order the alternating weekend schedule from Friday at 5 until Sunday at 5, and then also a midweek overnight Wednesday night. Okay.
Yes.
Okay. And let's see, we need the defendant's mother's been the exchange person for the children, the third party, because the PPO did exchange children. Is that what I heard?
She has been. The PPO didn't really prohibit exchanges, but now his bond conditions do. They bar any contact. So my client had worked with his mother and dropped off the children there. Okay.
So why don't we just say a third party? That way, if for some reason she can't do it, somebody else can. That's appropriate. I do think it's appropriate at this time that there be no contact with the children by either party's paramours. And specifically this.
After reviewing arguments, the judge ordered temporary joint custody, reduced transfers, alternating weekends, midweek overnights, supervised exchanges, and communication restrictions.
Latte Bowman. That all parenting communication be through our family wizard. If the attorneys need, I have a template that I use, and the two of you can tweak it to fit this particular case, if that would be helpful.
That would be helpful, Your Honor.
Okay, I'll ask the judge.
Okay, I can, my intention, I know that this is Ms. Curry's motion, but I can tweak the proposed temporary order, but I have prepared to include that language.
Okay, all right. That's fine.
I just would like to see any order, obviously, that Mr. Carpenter wants to draft before it's submitted to the court. Otherwise, I'll draft it.
Yeah, I will not submit it under 7 days. I'll send it to you.
Okay.
I'll even send it in Word format. So.
Okay. And I'll ask Ms. Van Oller to send you, both of you, a copy of my template, because there may be some things in there that it's a good idea for this case that you may not have thought of. Let's see. I will refer the issues of custody, parenting time, and child support to the Kent County front of the court. I'll waive the fee. I'll award the defendant temporary exclusive use of the marital home. Each party has exclusive use of their respective vehicles. I'll enter a mutual asset preservation order, no dissipation, transfer, or encumbrance of marital assets without consent or a court order. I'll reserve the 2025 tax exemption issue pending a further order of the court. Prohibit both parties from discussing this case with or in front of either of these children. That includes with third parties in front of these children. And I think I covered everything. Is there anything else?
The only thing would be the child support, Your Honor. I'd ask that the friend of the court determine that and make it retroactive to June 1, and that in the meantime, the parties share 50-50 the child care costs.
And I believe I heard Mr. Carpenter agree to that on the condition that that's actually needed, that they're working.
The court referred custody and support matters for investigation, preserved marital assets, restricted case discussions around children, and addressed temporary childcare expenses.